Well, speaking of training, I know that you also teach and train attorneys at law firms. What do you find they need the most?
In a one-word answer, what they need the most is context. And so we really start at the beginning of, okay, this is the complaint that you have and the theories of liability and the facts that are being alleged. How are you going to go about either proving or disproving those facts using information? And we used to just go to our client and get the stack of papers that they had and bring them back and start putting all of that together. Now you have to have this really proactive process where you're thinking about all the different kinds of ESI that can exist. The lawyers need context for why they care about ESI and why they need to know eDiscovery rather than just having their person handle the data. And so as we work through that process and they can understand, here's where I need to be thinking that my client probably texted somebody. Here's where I need to be thinking that they may have tried to use an encryption, and I need to make sure they're preserving all of that information. Helping them understand some of these new cases where crippling sanctions have been administered for just a pattern of behavior engaged in by the client. There's one case in particular, the Hunter's Capital case, where it kind of looks like the lawyers did their job in that they issued legal hold letters, things like that, but the mobile devices were still lost. And so it's really informative to these lawyers to understand the scope and depth of their obligations, be able to meet the Rule 26G requirements. And so we cover a lot of that in training. The organization of the training really depends on who we're talking to and what level of litigation strategy expertise they have.